in the purview of this body, because as the Senate President himself said in his measure, it is limited to infrastructure projects, past and present, but limited to investigation. In other words, it is a fact-finding body, and it will now recommend to the ombudsman or to the prosecutor the prosecution of cases. But commenting on certain areas,
On the issue of the sunset provision, what timeline are you looking at?
my just off the top of my head, subject to further discussion, the term of the present administration, June 30,
2028.
2028. But it's just something that we make as a reference. As I have no problems with my issue is it must have a sunset provision so that we will not have duplications. But to address the need for inadequacies in the system, we should strengthen the ombudsman. We strengthen the COA by adequate funding. That's my submission, Mr. Chairman. Rather than creating a permanent body which will again investigate or do work or do the functions of the ombudsman. That's my submission.
Yes, Chief Justice Puno, go ahead.
Are you done?
Well, there are others, but I can.
You may interject, Chief Justice Puno, in relation to the points earlier said.
No, I would like to former Senate President Drilon to continue. And then I'll also have my time to comment on the specific provisions of the Senate bill.
Yes.
So, just on the, going back, on the remedies or the powers which the one of our resource person mentioned, the issuance of an HDO, I would not agree that we place this in the hands of an administrative body. It must be a judicial determination because it involves the rights of individuals to travel, the right to abode. If you an HDO is a very powerful power of government, and to allow it must be a judicial finding. Other administrative remedies we would endorse depending on
perhaps the minimum would be a lookout order.
Lookout order. Yeah. Now, the controversial issue, Mr. Chairman, is the power to hold a person being investigated in contempt. We should be very careful here because of the right against self-incrimination. Remember that the persons being called to the hearing of the ICI face potential criminal liabilities. If the ICI or the body is empowered to recommend the prosecution of people. And having said that, if one invokes his right against self-incrimination, we cannot order the detention of that person until he cooperates. The example in the Senate or in the House cannot be cited because the objective of an investigation in the Senate and the House is in aid of legislation. Now, on the other hand, the ICI or this independent commission can recommend the prosecution, and therefore we cannot. I have very serious reservations about granting them the power of contempt. We have on. I think we should
on that point, Senate President Rilon. What you're saying is the remedy, perhaps, of this body, of this proposed body, would be to go to court.
Yes.
And seek the contempt order from the court.
Yes. Yes, sir.
And maybe the Court of Appeal, so that it's
whatever, but it cannot be no, and the principle, whether it's in the regular courts or in the or this body, where the contempt would require the answering of questions which can incriminate, whether it's in this body or in the court of law. To, in my mind, the right against self-incrimination.
For example, well, we
Yeah.
do have this case with the Discayas.
Yes.
They now refuse to cooperate with the ICI.
Yes.
Well, what is the remedy of the ICI? Or
The
what
rem-
should be
The remedy of
the
the
remedy-
ICI,
Yeah.
the remedy of the ICI is to assess what they have gathered as evidence, recommend to the ombudsman whatever action they find necessary, and the lookout of the Discayas is that the matter will be decided without their evidence that is presented. But that is how the system works, because another system could have more dangers. Now, the matter of it is also mentioned by the private, by the businessman, that some private group must approve the appointment of the president. I don't think that's possible, because the power of the president to appoint is constitutional. He is the appointing authority. He is elected by the people. For a private group to be given the power to pass upon these appointments, regardless of how well-meaning they are, I don't think that can stand constitutional scrutiny, Mr. Chair. So
they can recommend?
they can limit. For example, there is nothing wrong with recommendation, and we can even legislate, as proposed by Senator Soto, that the nominations of, say, of a retired justice must be passed upon by it can be exercised by some group. Integrated bar can recommend. The president's power to appoint can be limited by that. His authority can be exercised only on the nominees. Now, we have done that, Mr. President, in existing laws. I myself wrote that in the charter of the Professional Regulatory Commission, so that only those recommended by the professional body can be appointed as a member of the boards. Pwede po yan. So, I mean, we have done that.
Then in my case, the Coconut Levy Trust Fund
Yes, the Coconut Levy Trust Fund.
measure and the
Representative of the farmers
Yes.
must be nominated by
That's
the
right.
farmers group. Now, now, I can understand the impatience of our people, but we must remember that we have certain safeguards in the Constitution that cannot be disregarded, so that I do not whatever models we use, the first model that we look at is our Constitution, and let us not be carried by the desire to do away with certain procedures for the sake of what we see today. At this point, I yield the floor to my colleagues.
Thank you, Senate President Rilon. We have Chief Justice Puno. You have the floor, sir.
Thank you, Mr. Chairman. May I now express my thoughts on the various provisions of Senate Bill number 1215. First, the primary purpose of Senate Bill number 1215 is to create an independent People's Commission. The stress is on the word independent. The question is, how can we more or less determine that the commission sought to be established by Senate Bill number 1215 is independent. It is respectfully submitted, Your Honors, that we have to look at the structure of the proposed People's Commission from different dimensions to determine its independence. In accord with the known and recognized template used by the international community. What are these different dimensions to determine the independence of this People's Commission? First, its legal autonomy or independence. And we can perceive this from the different provisions of Senate Bill number 1215. Second, its budgetary or financial autonomy. Third, its operational independence. And fourth, its immunity and security against undue influence or retaliation. So proceeding from these different dimensions or the template provided by the international community, I respectfully submit the following observations. One, on the composition of the commission. I note that the chairman of the commission will be a retired justice from the Supreme Court. But I note that the nomination will come from the integrated bar. I like to inform Your Honors that the retired justices have their own organization. And perhaps the nomination should come from these retired justices. In the same way that this has been, this is the proposal with respect to the other members of the commission. There are certain questions on the matter, Your Honors. Are the members of the commission to be considered government officials, subject to all its rules and regulations, such as the filing of salary, full-time services, divestment of assets, and other prohibitions? Who determines their compensation and other allowances? And is there any provision on how they can be removed from office? We may also want to rethink the provision allowing the reappointment of members of the commission. And this goes to the conflicting thoughts on whether this should be an ad hoc body or a body with a fixed term. And all that question about the need for a sunset provision. Number two, on the budgetary independence. It is the wording of Section 8 on appropriation of the commission. Or is the wording on appropriation sufficient to guarantee that the commission's needed budget will be provided to ensure the success of its operation. Again, this will go to the different thoughts on whether there is a need for fiscal autonomy on the part of this commission, or not the traditional fiscal autonomy that we grant, let us say, to the Supreme Court, but a kind that is a hybrid in order to satisfy the this need for budgetary independence. Number 3, on its operational independence. We just heard from the chairman of IPI that the commission has only 3 lawyers.
But may volunteers na raw.
Yes. And Section 9 of the bill provides that the organizational structure and staffing pattern of the commission shall be subject to the approval of a DBM and consistent with the civil service laws, rules, and regulations. Since the commission should be independent, will not the approval of the DBM and strict application of civil service laws unduly restrict the operational independence of the commission? Or should we look for a sort of a middle ground, considering the need for powers of this independent commission? Fourth, on the immunity and security of the members of the commission. I note that there is nothing in the Senate bill that protects the members of the commission from harassment suits, especially after their term of office expires. It is respectfully suggested that this bill should provide some kind of immunity to the members of the commission. I have other observations and suggestions on the power of the commission. And this has been stressed by Senator Drilon. The power is only to investigate. After investigation, the commission has to go to the ombudsman or to the Department of Justice and recommend the filing of the proper charges. And the case has to undergo the usual preliminary investigation in the DOJ or the ombudsman. And it is the latter offices that actually will determine whether cases will be filed before our appropriate courts. The process, as I stress here, will be long. And the DOJ or the ombudsman may even set aside the findings and recommendations of the commission. And so, in effect, after giving the commission an independent status, its power is only to investigate. It is respectfully suggested that the bill should not only give the commission the power to investigate, but also the power to file the appropriate charges and the power to prosecute them. We hail the model of Singapore, of Hong Kong. This is precisely the point why those bodies are so effective. They have the power to prosecute, not just to investigate. not just to be glorified researchers. For this purpose, the commission can develop its own prosecutors or deputize some prosecutors from the DOJ, from the Ombudsman, from the Office of the Solicitor General, from the PAO to assist in the prosecution of the cases. It is also respectfully suggested that there should be a provision prohibiting lower courts, except the Supreme Court, from issuing TROs against the investigations being conducted by the Commission. It is also suggested that the extent of the subpoena powers of the Commission should be clarified. Can the Commission subpoena bank records, tax returns, SALNs, data from the AMLA, and especially if they belong to such personalities as the President, the members of Congress, or the justices of the Supreme Court and other independent bodies. There is also the
Well, what would you recommend in that regard, Chief Justice Puno?
again, extraordinary times require extraordinary remedies. As soon as these extraordinary times will be gone, when normalcy will again prevail, it is easy for Congress to get back all these powers.
Thank you. Thank you.
And there was also talk about giving the Commission hold order power. It hold the departure power. As it is now, it's only the court that can issue hold the departure order. But will we be violating the Constitution if we give this power to the Commission? I think we will be violating the Constitution if we deny the judiciary of this power, because essentially this is judicial power, but the Constitution does not prescribe the giving of this power to another body. In view of the extraordinary times that face us. I have heard the proposed amendments suggested by the Senate President, and I concur in all of them. Anyway, Your Honors, thank you for your invitation to share my thoughts on Senate Bill 1215, a piece of legislation which the country needs to pass without unnecessary delay in view of the crisis of corruption threatening our harmony as a people and the future of democracy in our country. Thank you, Your Honors.
Just a quick question, Chief Justice Puno. Based on your own inputs, you therefore, it is your position that the current ICI has inadequate powers to be able to address the largest corruption scandal ever in the country's history.
Yes, Your Honor, and I like to think that that opinion is shared by all the people in our country, especially the academic, the professors of constitutional law. And I like to think that this is considered even by the present IBI.
Maybe one quick question. it may take some time. I hope not. For this to be finally passed, will that not therefore become a added delay to our desire to have this resolved immediately? Number one. And number two, assuming it does pass at some point, then there has to be a transition between the ICI and their work towards, of course, the new body that is to be created.
Yes, Your Honor. But the President has made this statement 2 or 3 days ago that he supports the creation of this independent commission. That he realizes the inadequacy of the power of the commission, and therefore he in all for support the creation of this independent commission. If that is his position, he can always certify this bill as urgent. And I've seen also the counterpart bill in the House of Representatives. There are very few provisions that are opposed to each other, and so it will be very easy for both houses to agree on a final version of the bill.
Yes,
Mr. Chairman, just one question for my enlightenment. In your position on the powers that we should give IPC or the Independent People's Commission, you said prosecution, and that authorized something to the effect that they may be able to authorize the ombudsman or or deputize the Department of Justice. Do you think it would be legal, or still independence will be still in the commission if you include a representative from the DOJ or a representative from the ombudsman in the commission itself?
No, Your Honor, because these are complementary measures. The purpose of what, let us say, the ombudsman law and the purpose of this Senate bill run parallel to each other. They do not contradict each other. The creation of this independent commission will only strengthen the country's fight against corruption. So there will be no diminution of the powers of the ombudsman, the powers of the DOJ, because they will be complementary.
Thank you, sir.
Senate President Drilon, you may wish to answer the question of
I
Senate
cast a
President
dissenting vote with all due respect. You know, first, when you deputize a fiscal or a member of the ombudsman's office as part of the commission, the power there is moved to the commission because that ombudsman becomes, or that representative becomes part of the commission. We have the ombudsman who has power of jurisdiction. You cannot move the power of the ombudsman to prosecute to another body, not unconstitutional, unless we amend our constitution. And therefore, under the present set, it is my respectful submission, with all due respect to the learned justice, that we cannot transfer indirectly the power of the ombudsman to the commission by allowing members of the ombudsman's office to be deputized or to be brought as part of the office of this commission, because the authority to prosecute is transferred in effect to directly to the chairman of the commission. Now, so
what if the ombudsman consents?
no, the
You
consent is immaterial.
Is contrary to the constitution.
Yes, that's our position. It is contrary to our constitution. We cannot grant another entity the power to prosecute in courts or somewhere else the malfeasance committed. That has never been in power in any of the fact-finding commissions that we have created. The Feliciano Commission, the Davidi Commission, they were never given that power to prosecute. And if you remember, Mr. President, there was a proposal here in the Senate to allow private prosecutors in ombudsman cases. As a matter of policy, the Senate refused to grant that kind of privilege because you prosecute here public officials and you cannot allow private prosecutors. That is a policy issue which the Senate rejected as correct. So that's why we have reservations about transferring the power of the ombudsman to another body.
Chief Justice Puno.
Yes, Mr. Chairman, we are not usurping the powers of the ombudsman. There are powers as defined in the Constitution, and the laws will be there. But we are giving prosecutorial powers to this independent commission to complement the powers of the ombudsman. Now, this is a matter of deputizing. It does not violate any law. For instance, the office of the Solicitor General. The office of the Solicitor General, since time immemorial, has deputized prosecutors from the Department of Justice to handle cases in the lower courts. And nobody has challenged the legality of that deputization.
Well, Mr. Chairman, with all due respect, the deputization of the Solicitor General by the Department of Justice Secretary is because they both belong to the Department of Justice. And this only later it evolved that there's some degree of independence on the part of the OSD. But the OSD is essentially part of the Justice Department. Ang problema ko po, if you allow deputization, then you transfer the power of supervision over that prosecutor from the ombudsman to the IC. It is constitutionally doubtful with all due respect to Chief Justice.
Yes, we may have to study this, but yes, Chief Justice, go ahead.
Yes, but again, the emphasis is that these are complementary issues. The ombudsman, the power of the ombudsman to investigate cases, prosecute cases as defined by law, will still be preserved. But under the present situation, there will be new cases that will be filed before the independent commission. And these cases will not interfere with the cases that are being filed in the ombudsman. And so there will be no conflict of powers with respect to the cases that will be handled both by the commission and by the ombudsman. As I said, they will be complementary.
Yes, just for the record and for the information of Senators Dillon and Chief Justice Puno. The Anti-Agriculture Economic Sabotage Council, which was a creation of Congress last year, September 2024, a Section 17 special term of prosecutors to assist the Council, the Anti-Agriculture Economic Sabotage Council, in the expeditious prosecution of criminal cases covered under this Act. The DOJ Secretary of the DOJ is hereby mandated to constitute a special team of prosecutors all over the country, which shall have the following powers and duties, among others: evaluate evidence gathered and submitted by the
enforcement group of the council act on criminal complaints directly filed by persons under Section 21, initiate and conduct preliminary investigation. So in this particular measure, which is now law, it is the DOJ that is mandated to create. So perhaps we can marry the two proposals, wherein it's the ombudsman that will create a special team, or the DOJ will create a special team of prosecutors to address the issue or the cases recommended for filing by the IC, by the Commission. Yes.
In fact, sir, that is one of the things that we felt would be important. With the point of Senator Drilon is very well taken. We don't want to add layers of bureaucracy to this thing. We feel the business community, I think I speak for the business community, feels that the ombudsman itself needs to be strengthened in order to handle this volume of cases. It's simple math, no? I mean, the volume of cases is in this affair alone, the flood control or whatever you call it, infrastructure alone, is so enormous that if you had to hand all of these things to the ombudsman as it exists today, they would come to a standstill. The throughput would be terrible, you know. So we believe that they need to be strengthened as well. And I think a practical solution can be found.
Thank you. Thank you. Yes, go ahead, Senate President Drilon. Speak before the mic.
Yeah. Okay. One of the suggested provisions I have in mind is to direct by law the Supreme Court to vacate the docket of one of the Sandigan Bayan branches and refer all the cases coming from the commission to that particular branch so that the trial can be done every day and finish it within the shortest period of time. Because that's one of our problems today. The delay in the resolution of the cases erodes the confidence of our people in our justice system. That is why I was just consulting with the Supreme Court can vacate, can vacate the docket, and designate one division to handle all of these cases, it can go a long way.
Yes, and the delay has led to dismissals of cases.
Yeah, yeah.
In fact, the conviction rate based on the budget debates, the conviction rate of the Sandigan Bayan is 47%. Therefore, for every 2 cases, 1 is dismissed. Now, as to how long those cases were resolved is another issue altogether. So, yes.
Very quickly.
Go ahead,
Mr.
Secretary Babes.
Your Honor, just for orders of magnitude, just on ghost projects alone, 421 potential cases. Nothing else, just on ghost projects, 421 will land either in the ombudsman or in the Sandigan Bayan. How do they handle 41 cases? 421 cases. Let alone the other projects, substandard, ghost projects pa lang, 421 cases.
And one case would probably include anywhere between what, 10 to 15 accused per case?
Because everyone involved in those projects, we will include.
That is the Bids and Awards Committee, the contractors, of course,
officers of the DPWA,
yes, yes.
COA, everyone else.
Thank you, thank you. Yes, Chief Justice Puro.
Yes, on that score, Mr. Chairman, this committee or the Senate may consider passing complementary laws on how to fast track the resolution of these cases. You know, creating special subdivisions in the Sandigan Bayan, maybe one or two, or if there is still a further necessity, creating a new, entirely new subdivisions. And perhaps the committee may also look at, how to fast track the resolution of these cases by looking at the evidentiary requirements. Maybe we can adopt some presumptions where after a certain acts are proved, then the burden of evidence can be shifted to the respondents. And all these things are not new ideas. They have been adopted in other countries, and this prevented the state-based resolution of cases. And so, as a complementary measure, you may like to pass special laws on the prosecution of corruption cases.
Thank you, and it might become a rider if included in this measure. So, yes, another bill. Yes. Would the DOJ care to comment on the debate as to deputization and or creation of a separate team of prosecutors?
Thank you, Mr. Chair. I did not want to engage in a debate between the legal luminaries, Mr. Chair, but just to give the committee some insights. The Department of Justice serves as the principal law agency of the government, and this is under the Administrative Code of 1987, which is why and the two functions of the Department of Justice is to serve as the prosecutorial arm of the government. Hence, any deputization of prosecutorial functions is not really allowed, except under the rules of criminal procedure, where deputization to private prosecutors will be allowed, but they are still under the direct supervision and control of the public prosecutor. We have also reviewed the provisions proposed IPC Chair, and we laud the objective behind the passage of the bill to address the grave issues of corruption that are being discussed right now in a different public fora. But there may also be possible duplicity of functions here, Mr. Chair. Duplication, as already mentioned, the Ombudsman already has investigative powers. It might raise the question of what if the findings of fact of the Commission would differ from that of the Ombudsman, which would prevail. So possibly enhancing already our institutions in place, strengthening them, capacitating them more, giving them more maybe budgetary support, manpower support would be ideal. But if we understand why the committee would push for the passage of this bill, and the Department of Justice supports, subject to the submission of our position paper on how to refine other provisions of the bill, so that there won't be any legal questions that can be raised later on. Thank you, Mr. Chair.
Yes, please. And on that note, maybe request the committee secretary to likewise send communications to the Ombudsman, for the Ombudsman Office of the Ombudsman to submit their position paper on this matter. Thank you. Yes, Apat, go ahead.
We just wanted to know from history, the Ombudsman has actually only existed since 1988. Previous to that, the Commission was granted, was given the powers to prosecute, and many others. That was the Presidential Commission on Good Government. Okay, so there is a legal precedent, right? But this was presence of the ombudsman right at the time. But once the ombudsman's office was formed in 1988, the PCGG continued to have those powers.
Yes, because both the PCGG and the Ombudsman are constitutional entities, and therefore they can. It'll have to be harmonized.
But the PCGG was not under the Department of Justice, as far as I know.
It was not. It
Yeah.
was not. Yes. Yes. Okay. We note that. I don't have. Yes. Justice Reyes, go ahead.
We take note of the confines as mentioned by Secretary Dillon, and we'll be very happy if the powers suggested by the Chief Justice Puno will be given to us, because I have noticed that there are some powers we lack, that like bank secrecy law, tax records. You can imagine that the flow of money was by cash. So it's difficult to really trace how the money went about. So we need this financial banking rules to be able to perhaps determine where the money went, and to get the money and the amount. And of course, we would also like to have the power to look into text messages of these people, because I'm sure that one or the other exchange of money was done through text message between the official and the contractor. At any rate, we are so happy with the suggestions and of the Chief Justice, and we would like it to be adopted as much as possible by this committee.
Thank you, Sec Babes, and then Chief Justice Puno.
I'd like to also mention the importance of immunity from lawsuit for the members. Kawawa yung member dyan after they retired. Mauubos sila sa lawsuits.
Kaya baka hindi na mag-imbestiga. Pathetic na lang, di ba? Okay, yes, we know that. Go ahead, Chief Justice Puno.
Yes, on the lack of power of IPI. I note the statement now that the money that is the subject of these crimes do not anymore go to the banks. They are physically deposited to, if we are to believe it, in apartments, in condominiums, and so on and so forth.
Condominiums, which are also fruits of the illegal wealth. Yes.
But that raises the question, Mr. Chairman, on whether you should give this commission the power of search and seizure. That is the question.
Well,
Of course, consistent with the protection given in the Bill of Rights.
yes, we will note, but that's very interesting. Or maybe that the commission can secure the warrants direct from the Court of Appeals, or search warrants direct. So, if I understand, it is for the commission to be able to have the power to seize and to. Yes, we will.
Or go to the procedure in our terrorism law.
Yes, there are provisions in the anti-terrorism. Well, council can
Just to the Court of Appeal.
yes. Just to rewind our colleagues, we abhorred the system of ASO during March and let us not put that back into our statute book.
The proviso is that consistent with all the protections in our constitution, especially the protections in the Bill of Rights. But that is one kind of a solution. They
Yes,
can go to
yes.
the Court of Appeals, and again, the Supreme Court can designate specific divisions of the Court of Appeals to handle this matter so that the process will be very speedy.
Yes, yes. Thank you, Chief Justice Puno. Yes, Justice Reyes, go ahead.
Yes, regarding search and seizure, I have been toying with the idea because if an office is engaged in wanton fraud and we know it's happening there, we should be able to take hold of that entire office. Nobody can be allowed to remove documents, and the employees will not have access to that room until we have gone through every record, every USB, everything that's there inside. That way, we can really be able to notice or discover some wrongdoing on the part of that office.
Yes,
think
I
this-
remember
thi-
initially you were expressing serious concern or grave concern about the burning or destruction
Yes.
of public documents.
Yes, as per record now, the burning in Quezon City does not involve flood control projects. But I did had a meeting with the COA, and I told him that we have to secure all the records of the COA because as an investigator before with the ombudsman, I know that there's a tendency for the criminals to burn down the office, which happened in the Cebu scandal when they burned down the entire treasury building in the 1980s.
It may not involve flood control projects, but what about farm to market roads? Yes, Mr. Ong,
This is actually one of our issues naman that we are trying to work with the DBM about. The issue is transparency, right? A lot of government agencies are resisting digitization because they want to keep everything on paper, right? And when you keep something on paper, it's not transparent. You have to go there to request access to the documents. You can't just find them online, right? So this is a struggle that we've been having, and the DBM has shown great initiative in this. No? But you know, the other guys, the DOJ, DPWH, we need these things online,
BOC,
not on paper.
BOC.
BOC, BIR. Yan.
Well, the anti-agri-economic sabotage laws mandates that within 90 days of September 2024, the single window digitalization should have been operating. So that's not the case yet. Thank you, Senate President.
Mr. Chairman, yes. Well, just a short quip. There are some of us who are in love with human intervention. That's why they disagree with digitalization.
Thank you. Yes, Professor Abante, go ahead.
Thank you so much, Mr. Chair. Would the committee be open to consulting transitional justice and restorative justice experts to also chime into the bill? The reason why I ask po is we know that our society's social fabric has now torn. And we need to have a structure in which the people who are convicted are able to apologize to all of the families that have been affected by the corruption. I imagine, public officials, contractors, who have a face-to-face encounter, or depending on what the restorative justice experts say, is a good and culturally sensitive way of mending these broken relationships that we have. And this is coming from, we can think about what happened after the end of apartheid in South Africa, and in many other, transitional justice courts that happened all around the country. So perhaps that may be my first input. I have second input.
Well, we're willing
Mr.
to
Chair.
get their position papers and take a look at it. So if you can help us, Professor, in that regard, please get these groups to coordinate with us, submit position papers, and we can review them and see how a number of those provisions may or may not, but may be incorporated in the final report and the measure and the law. Go ahead.
Thank you, Mr. Chair. My second point is around just the massive scale of all the cases that need to be filed. And I imagine that even if the commission is legislated, there is just too much to investigate. So can there be complementary measures that can help the broader community beyond the commission to do fact-finding and investigation? Can we make it easier for our community of investigative journalists, for example, to look at these potential conflicts of interest? I was talking to investigative journalists, Casey Valmonte and Dwight De Leon of Rappler, who broke the story on the probe of Representative Zaldico. It cost them 30,000 pesos to get the Securities and Exchange Commission audited financial statements, general information sheets, and articles of incorporation, meaning it's very expensive for investigative journalists to do this work. We hope that the Honorable Congress can ask SEC to make these documents open and free. There is a beneficial ownership registry that is supposed to be made public under the new Government Procurement Act. It's scheduled according to the PhilJeps to be launched on January 2026, but perhaps this can be accelerated given the extraordinary cases that we're filing. And then finally po, we are happy to also share that we worked with the PhilJeps to open up all of the awarded contracts since year 2000. So they are now published, Mr. Chair, in the PhilJeps website, and Civic Tech volunteers have already looked at 5 million contracts that are published now in the PhilJeps. So thank you to the PhilJeps and career servants at Procurement Service TBM for doing this. But these are the types of proactive disclosure that I think APA was referring to a while ago. The problem with the current system in PhilJeps, we need to transition a lot of the agencies into the e-bidding facility. Right now po, ang PhilJeps, yung posting lang po ng opportunities, tapos yung posting ng award. In between po, a lot of the bidding is still manual. But there's, under the new modernized PhilJeps, they can transition into using the e-bidding facility. Meaning hindi lang yung nanalong bidder yung pwede yung ma-check, pero kahit na yung mga competing bids. So you can check actually all of these matters, and we need to support the transition of the agencies into the e-bidding facility. Thank you, Mr. Chair.
Okay, we will look into possible transparency and freedom of information provisions in this measure. But I guess the mother code must be the different freedom of information measure, no? The bill. Yes, sir. Justice, and we
Have been having talks with DPWH, DICT, CICC, Agriculture, Health, DepEd, LRA, DTI, COA, BIR, SEC, DOJ, OSG. We have been talking with them for the last almost 30 days, and we have come to the common effort that we will coordinate everything. So we will be able to address all the address the holes, that loopholes in the system. And right now, we already have the full support of the PNP. So every barrio or every city where there is a PNP they will be able to verify for us if there is such a flood control project in that area. So that was organized yesterday. We agreed to that already yesterday. We'll be utilizing the 17 drones of the PNP.
17.
Yes, 17 regions and 17 drones.
Okay, thank you. Yes, Sec Babes.
May I just follow up on the discussion as far as participation of the communities, you may want to consider in a provision of the IPC to enshrine citizens' participatory audit. That was instituted in 2012, and that was recognized internationally as a good forum for the citizens to be given a platform to review the budget, participate in the audit, participate in the review of implementation of projects. Unfortunately, this has not been changed. It's a COA initiative, but it really depends on who is the COA commissioner. No? But my suggestion is if this can be enshrined in your proposed IPC so that all agencies are required to institutionalize a citizens participatory audit so that everyone, all citizens who want to, for example, Department of Agriculture, then the groups related to agriculture can have a direct participation. Mr. Chairman.
Actually, this was there was a preliminary discussion on the budget, the DBCC budget hearings, where the DBM was there, the DOF was there, DepDev was there, and of course the chairman of the Committee on Finance of the Senate, Senator Gatchalian. And we were actually proposing, I was proposing, that in the GAA there will be special provisions on citizens participatory audit. So that is something that we're working on. Thank you. Yes, Senate President Drilon.
Yes, just in that regard, there are many good ideas that we hear around here. But so what we have to contend with the constitutional rule on multiplicity of subject matter in a single bill. May I suggest that all of these ideas, like the idea of Secretary Bibbs, the matter of the citizens' participation, may I suggest that a resolution of the Senate expressing the sense of the Senate that the President should implement whatever just to show support without being in the law because matagal ang proseso. But siguro a resolution expressing the sense of the Senate finding as valid and workable ideas such as this for the President to direct the bureaucracy to implement it immediately. That's a faster way of doing it, if I may suggest.
Thank you for the suggestion. We will file that sense of the Senate resolution, and of course with the support of the Senate President, I'm sure it will pass smoothly. Well, I think we have had a number of provisions and proposals to chew on. Thank you to the esteemed resource persons who have contributed. Unless the Senate President has other questions or issues that he may
No,
wish to raise.
I would just like to thank you, the chairman, Senator Francis Pangilinan, and of course our resource persons. Thank you very much for this committee hearing that they have attended. I am indeed, for one thing, I am amused and awed by the spectacle of the debate between the former Chief Justice and the former Secretary of Justice. I think the scholars of the future and the students of law should be listening to this kind of debates from such luminaries. Thank you very much, sir.
Inquiry, Mr. Chairman.
Yes.
For the benefit of the public, may we request that the committee report on the basis of the inputs in committee hearing today, and if there's no further committee hearing to be held, that the committee report be immediately drafted and it be calendared on the first day when the session of the Senate resumes. Request a certification as to the urgency by the President and have it passed before we start the budget debates, because traditionally, the moment the debate is on the floor, no other bill is taken up. So I suggest if there is time, we can do it before the debate on the budget starts.
Yes. In fact, we will have one technical working group after this, and so we would request our resource persons to submit their written position papers, and that if they may send representatives to participate in the technical working group meetings so that we can prepare the committee report. And yes, that was the intention actually. The Senate will resume sessions in November 10. So by then, which is 3 weeks from now, we hope to have that committee report sponsored and seek the certification of the Office of the President. Just for the DBM, may we request you to also comment on whether or not there will be available appropriations to support the creation of this body, your position paper there, and have you released funding for the ICI based on EO 94, and how much has been released? Just to
Good afternoon again, Mr. Chair. And for the information po, we have received the request from the ICI for funding requirements, and the same is being under process na po.
so in the meantime, abonado sila, ganun? Is that it? Well, you know, the DBM should act with dispatch.
Yes po, we have received the request this month lang naman po,
Okay.
Mr. Chair.
Okay, so with that, ano na tayo? Adjourn. Suspend, yes. With that, we would like to thank our resource persons for this very fruitful hearing on Senate Bill 1215. Thank you. Maraming salamat sa inyo. The Committee on Justice and Human Rights hearing is suspended. Thank